Well, good morning. Welcome back to Federal and Indian Gaming Law. Today we'll talk about the Wagering Paraphernalia Act and the Travel Act. This is a relatively light class compared to some of the other classes we've had. Should send you off to spring break in a pretty easy way. So again, starting off as we often do, we'll take a look at those elements. Remember, don't forget the elements that we learned about in the first few classes, and the variation on tests used to determine whether those elements exist in any particular promotion or event. Again, don't forget the essence of the Wire Act, sort of what it covers. It covers those in the business of betting or wagering. Good thing to know, and not forgetting the pre-2011 DOJ interpretation is probably a good thing to know. Knowing the Lombardo interpretation, the 2011 interpretation from the DOJ memo or a memorandum, and from the January 2019 memorandum, and the limited exemptions. We also went through the Illegal Gambling Business Act. Kind of remember, what does it prohibit? Prohibits anybody from owning, managing, financing, supervising, or conducting all or part of a illegal gambling business. And what is an illegal gambling business? Well, one with 5 or more people that do any of those things. It operates in violation of any state law in which it operates. And it's either in continuous operation for 30 or more days, or earns $2,000 or more in a single day in gross revenue. So it's a very low threshold. Oops. Are bettors part of the illegal gambling business? No. These are all supply side. And you remember what it means to conduct an illegal gambling business? Again, low threshold. Let's see if we can keep people awake a little bit. Alex.
It's doing anything that's necessary or like helpful to the business.
Yeah, necessary or helpful. So it's a really low threshold. And what does it mean to, again, being a janitor counts, providing a line subscription, and do you even have to be paid by the operation? And the answer is no. Karen Fallon wasn't. So let's turn our attention to the Wagering Paraphernalia Act. Now, the Wagering Paraphernalia Act is another one of these statutes enacted to combat organized crime and interstate gambling, and specifically, it prohibits the transmission or transportation of interstate commerce of wagering paraphernalia, either yourself or through a common carrier. So, it's through a common carrier. So if you knowingly carry or send interstate or foreign commerce any record, paraphernalia, ticket, certificate, bill, slip, token, paper, writing, or other device to be used or adapted, devised or designed for use in bookmaking, wagering pools with respect to sporting events, in any numbers, policy, bolita, or similar game shall be fined or imprisoned. So it's a relatively broad statute. And again, this applies to pari-mutuel betting equipment, or unless it's legal in both states where it's being transmitted or transported to and from. Again, you have some limited exemptions, but again, those exemptions only apply if the equipment is legal in the states in which it's being transported to and from. So we come to the Mendelssohn Opinion. This is one of my favorite opinions in the coursework. It reads pretty well. Anybody remember the facts of this one? Alex.
Yeah, these two people, Mendelssohn and Benson, had mailed a floppy disk from Nevada to California. And actually the person they sent it to was an undercover cop posing as a bookmaker. So that obviously wasn't great for them.
Great. Yeah, and what was on the disc?
Oh, it was like a program for sporting events and like betting, and it was like recording and analyzing all that information.
Yeah, they developed software to help run a book, essentially. And they claimed it was an accounting program called SOAP. But it had a lot of features that were useful to bookmakers, like computerized methods for analyzing sports bets, game schedules, point spreads, odds calculator, and what every legitimate accounting system needs, a quick erase feature to destroy all the data. And for a fee, you can get a recovery program to recover the quickly erased data that you've tried to remove. So yeah, they end up selling it to an undercover policeman posing as a bookmaker in California. And they get convicted under the Wagering Paraphernalia Act for sending that. So what were their defenses? Well, first one was the disc is protected speech, commercial speech. We'll talk about commercial speech later in the semester. The statute is overbroad. The disc qualifies as a newspaper, similar publication for an exemption. The software isn't a device, nor is the disc. There was no intent to violate the law. That never works. And my favorite defense, reliance on a legal opinion. So what does the court think of these? Well, is the disc actually protected speech? And the answer is no. There's no protection for speech that promotes an illegal activity. So here the court said, no, any speech that's embedded in the software is too instrumental and intertwined with the performance of the criminal activity to retain any First Amendment protection. So SOAP and the information in it and the way it works is not protected speech. The statute is too broad. Well, the court says no. We're not going to validate the statute simply because there are marginal applications that might infringe First Amendment values. So it's not overly broad, although it is expressly designed to be read broadly. With regard to the newspaper exemption, no. It doesn't bring news of any type. It contains information about races, games, bets, and betting strategies. So it's really there to help computerize the bookmaker's system of keeping records and bets. And it's not a newspaper. And it would be a real stretch to say that it was. Now, with regard to the software not being a device or a disk, this is actually probably their best argument because everything in this statute deals with the transmission or transportation, I should say, of some kind of tangible good. And here, looking at the congressional history, Congress wanted this to apply to anything that was used to record bets, such as blank lottery tickets, bookmakers' records, flash paper. Remember seeing the flash paper in the video from the FBI? You know, they put the paper in water and it instantly dissolves or instantly burns if you put a match to it. You know, on the contrary, Congress employed broad language to keep pace with the latest developments. So you can see this isn't going to go far. Whatever merits the defendant's argument may have with regard to such generic terms as pencils, it doesn't encompass their computer program that was far more narrowly targeted for use in bookmaking. So, they argued that, well, the way, you could read this statute to include pencils and regular paper and anything could be wagering paraphernalia. And the court's saying no. As applied to you, no. This is a computer program that is really narrowly targeted for use in bookmaking. Again, anybody ever work in accounting? Anybody ever see accounting software? Anybody familiar with QuickBooks, Peachtree, anything like that? I'll tell you, having worked with those things in the past, none of them had a quick erase feature. Oops, the police are here. I need to erase all of the accounting data. That's not a standard feature of an accounting system, nor is features for analyzing and recording bets and the outcome of sporting events or the dates and times of upcoming sporting events. So, no intent to violate the law. Here's another one. Again, in the United States, you don't have to knowingly intend to violate the law. You just have to know that you're doing the conduct that the law prohibits. And here, they knew what they were doing. It's pretty hard to argue that SOAP is a standard accounting program. It's pretty hard to argue that it even has any application outside of bookmaking. And they knew they created this program for bookmaking, and they knew they sent it to people outside of Nevada. Whether or not they knew it was illegal is irrelevant. All they have to do is know that they're engaged in the activity that the statute prohibits. And this is a theme you'll see across the board with federal gaming laws. And my favorite defense, although probably the worst one, is reliance on a legal opinion. So Mendelssohn told the detective that his attorney said that selling soap was legal. He later told Felix that his attorney said that he didn't know what would happen if Mendelssohn sold soap in interstate commerce. Over the defendant's objections, the district court found that a limited waiver of the attorney-client privilege permitted Mendelssohn's former attorney, Raby, to testify that he told Mendelssohn that sending soap outside Nevada violated federal law. So they wanted to use their legal opinion to say, hey, not only did we not intend to do anything illegal, we got a legal opinion that said what we were doing is legal. Until the attorney-client privilege was waived because they were relying on that opinion, and it said, the opinion said, no, you sell this thing out of state, you're going to violate federal law. So I guess that's one thing, is if you do work somewhere and you have opinions from attorneys, don't use them as defenses if the opinion of the attorney tells you, hey, what you're doing is illegal, or what you're planning to do is illegal. Thoughts on this one? I think that the reliance on opinion is fascinating. Just the fact that they would even use that as a defense is fascinating, particularly when the opinion says what you're doing is illegal. And I've written a number of these opinions for people. Sometimes they want them, sometimes they don't. But when they do, it is what it is. Often these are the opinions that say, hey, what you're doing or what you're planning to do is illegal. Those are commissioned usually by foreign entities. And it lets them know that they probably shouldn't be doing what they're planning on doing, or what they're doing is illegal and they should probably stop. What you can't do, in your opinion, is tell them how to evade law enforcement, other than saying, stop taking bets in the US, stop doing the illegal activity. But you can let them know what the law is, and that what they're doing is putting them at risk of arrest and prison. So interesting case. It's a fun read if you haven't read it. Just the fact that they really don't have a leg to stand on in their defenses. Now, the more interesting question comes, what about just transmitting in interstate commerce over an internet connection where there's nothing tangible? And I think that's going to be an interesting case if law enforcement ever tries to use the Wagering Paraphernalia Act against an internet transmission of software like that. US v. Norberto. This is a confusing one, but there aren't that many Wagering Paraphernalia Act court opinions, and it does have some value for us. Does anybody remember the basic facts? Well, defendants are accused of operating an illegal gambling business in the US that sold tickets in a Spanish lottery. The lottery is called El Navidad, and the big prize is called El Gordo. Spanish lottery actually prohibits individuals from taking those lottery tickets outside the country, although, like a lot of things in particularly Southern Europe, lots of laws, little enforcement. So it's often disregarded, well known to be disregarded, that rule of don't take the tickets outside the country. Defendants set up operations in the US and Canada to promote, import, transport, and sell those lottery tickets around the world. They use a complex web of companies to kind of conceal the nature of the operation and to launder the proceeds. And lottery solicitations are made through the mail and internet solicitations all over the world. So let's take a little detour first, though. Let's talk about lottery. Lottery laws were the first federal laws to address gambling, or I should say lottery prohibitions. And one of the first was 18 U.S.C. 1301, which gets mentioned several times in this opinion. And what does 1301 do? It basically prohibits the transportation of lottery tickets across state lines. Also prohibits the transportation across state lines of lottery advertisements, unless the scheme is approved by both states and the states have some kind of an agreement between them. So this is why you don't see California lottery ads in Nevada. Notice no billboards for California lottery here. You don't get mailers. You don't get anything. You don't have businesses that are selling California lottery tickets because it's illegal under federal law. Same thing in Arizona. Arizona has its own lottery. Anybody here from Arizona? Anybody here from someplace other than Nevada? A state other than Nevada?
Florida.
So you have, Alex, you have lottery in Florida, right?
Yeah, they got Mega Millions and scratch offs and
Right.
Powerball.
Can you buy a California lottery ticket in Florida?
No.
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 No, exactly. And that's the same across the country. Even though you have bordering states like Arizona and California, you can't buy a California lottery ticket in Arizona and vice versa. And even things like multi-state products like Powerball, you're still buying a California lottery ticket. The proceeds actually do go to California, but California then contributes to a multi-state prize pool. So you're not really playing lottery across state lines. You're playing lottery with the state of California. It's just that the prize pool is sort of like a progressive across that lots of states contribute to. So we don't really have interstate lotteries. Lotteries are a state-by-state activity. And why do you think that is? What do lotteries do for a state? Hey, Alex, was the lottery do? Oh, yeah, Alex, what do you think?
Will they bring revenue for the state?
Right, revenue for what?
For I mean all kinds of things. I don't know exactly. I don't know if that varies by state or not.
I mean, it brings revenue for state government, right? Lotteries fund state government, and what the federal government does is it keeps that funding of state government located within the state in which the lottery is offered. Eugenia, you got a question or comment? Oh, maybe not. And there's something offensive about the citizens of one state funding the government in another state. So, there's a fair amount of rivalry between California and Arizona. Is anybody here from Arizona or California? Alex?
Yeah, I'm from California.
Yeah, I mean, California probably doesn't have as big a rivalry with Arizona as Arizona does with California.
Not that I know of, at least.
I don't think Arizona matters all that much to California. But in Arizona, California's a problem. Californians are problems. The same thing in Oregon. Anybody here from Oregon? So there is something, I think folks in Oregon would be less than happy, and folks in Arizona would be less than happy if California was trying to fund its state government by selling lottery products in Oregon or Arizona. So, and this is often the reason that states use to promote the introduction of a lottery in their state. Now, we haven't had an introduction in a few years because most states have state lotteries. There are only a handful of states that don't. When I was growing up in Wisconsin, Wisconsin, by referendum, changed the constitution of the state to permit a lottery in 1987. Turns out that was the same year of Cabazon. What a coincidence. But the reason that the state authorized the state lottery in 87 is that Minnesota, Iowa, Michigan, and Illinois all had state lotteries. And so every state on your border had state lotteries. And every time prizes got big in those states, people from Wisconsin would drive across state lines to buy lottery tickets. If you're here in Nevada, you know that when Powerball gets big, people rush over to Arizona and to California to buy lottery tickets. There's actually a lottery sales office, I think, for California, just off the 15 and inches within the California-Nevada border on the California side. Anybody ever seen that? It's just south of the mall in Prim. There's that casino, there's a mall, there's like a McDonald's and a Taco Bell. And if you keep going through the parking lot or that frontage road, there's a little building that sells lottery tickets. And that happens to be in California, but only by inches. But it's there. And when Powerball gets big, that parking lot is overflowing with Nevada license plates. But again, federal law respects states that want to have a lottery, and it respects states that don't. And there's something offensive about having one state trying to fund its state government with funds raised in another. So we don't allow the transportation of lottery tickets in interstate commerce. We also don't allow them to be mailed or advertisements about them to be mailed. When we get to First Amendment, we'll talk about this again. And there are a series of exemptions. Are there exemptions? And we'll talk about that when we get to the First Amendment a little bit later on in the semester. But there are a few exemptions, and the exemptions deal with activities that are illegal in both states, right? Consistent with that federal policy. So what does the defense of these guys put up? Well, what they say is, well, actually, what we're doing falls within the exemption because the lottery is authorized. And what we're doing is just helping an authorized lottery. Now, the government says, no, this isn't authorized because this only applies to situations where the foreign country itself conducts and administers the lottery for which solicitations are sold, and you're not working on behalf of that government, and you're not selling tickets to a lottery that's authorized by the laws of that foreign country, because the laws of that foreign country prohibit taking lottery tickets outside the state or outside the country. So it doesn't merely mean that they permit you to take the, Norberto's argument as well, it might be illegal, but they just permit us to take the tickets out, and that's not enough. Authorizing must be an actual affirmative granting of formal approval or permission. It's not merely permitting or allowing. And again, what you're doing is illegal. It's not authorized by the Spanish lottery, and you don't fall within the exemptions. And again, the lottery solicitations were to be used for this lottery game. And therefore, your conviction stands. Now, it's interesting because the lottery itself was legal in Spain, but what they were doing was not within the authorization of the Lottery of Spain. The other thing is that promoting a Spanish lottery in New York wasn't allowed under New York law either. So that's kind of the Wagering Paraphernalia Act. It doesn't get used a whole lot these days. Where you do see it used, I would say, is when you have, well, bookies that are going and providing services in interstate commerce. So you'll have bookmaking slips. You'll have a bookie in California that may come to Nevada or may go up to Phoenix or something, and they're carrying books and parlay cards and things like that. Less so now because the bookmaking business has completely changed. And when we get to sports wagering, we'll talk about Paperhead and how this has all changed. But the Wagering Paraphernalia Act is still on the books. It still prohibits the transportation, interstate commerce of all these articles used for wagering. And any thoughts on that? Austin?
So just domestically, for this exception, it can't be enough just that two states like California and just say hypothetically Nevada allow a lottery. Both states have to authorize not only a lottery but also taking and receiving out-of-state advertisements and things like that.
Yeah, and most states do that. The only thing they do cooperatively with lottery really is the multi-state lottery products. The other thing it permits is it permits companies like Scientific Games and IGT to set up shop in one state for printing purposes. So for example, Scientific Games lottery division, which I think they're spinning off or spun off now, operates out of Georgia. So all the tickets, the scratch offs, things like that are actually printed there for lotteries around the nation. Now, what they can't do is sell those tickets in other states, but they can transport those tickets from Georgia to California, because in Georgia it's legal to produce those, and in California it's legal to sell and use those. Otherwise, they would have to set up printing operations in every state, and they don't need to do that under this law, which makes some sense. Does that help?
Yeah, thank you.
Louis?
Yeah, I was just going to ask whether or not, the functions that like third-party payment processors provide, would that touch that, or would that not be really considered? Because it's not considered to be like actual things used for bookmaking.
Right.
It's just an intermediary.
Payment processors, as long as they're not violating other banking laws, generally okay. And that was kind of the focus of the letter from New York and Illinois lotteries to the Department of Justice back in 2009, 2010, is they wanted to sell lottery subscriptions in the state, in their own states, but use an out-of-state payment processor. And that's fine. You're not funding the Illinois lottery with sales in Utah just because you're using a Utah payment processor. So that doesn't offend the policy that's behind this. Other questions or thoughts? All right, let's move on to the Travel Act. Now, the Travel Act is a really broad statute. It's not used in the gambling context often, but it's used in a lot of other contexts. And basically, let's get this whole thing up here. What it is it prohibits anybody from traveling in interstate or foreign travel with the intent of distributing the proceeds of any lawful act or committing any crime, violence, or any unlawful activity, or otherwise promoting, managing, carrying on, or facilitating the promotion, management, or carrying on of any unlawful activity. So basically, you can't cross state lines in order to engage in an illegal activity or to distribute the proceeds of an illegal activity. You see this a lot with human trafficking. You get Travel Act violations and with the illicit drug trade. But every once in a while, that illegal activity will include gambling. But you don't see it a whole lot with gambling. Again, most often used by narcotics cases, and I should say human trafficking, prostitution. But it gets very broad interpretation by the courts. And for our purposes, Polizzi is probably the best opinion to look at. Does anybody remember the basic facts, Polizzi? Well, Polizzi and Zarelli and others own an interest in the Vegas Frontier Inc. Vegas Frontier Inc. owns the Frontier Hotel. Frontier Hotel was located where, you know where the Trump condo tower is next to the fashion show mall? That used to be the Frontier, or at least part of it. So at the time in the 60s, Frontier Inc. owns the Frontier Hotel Casino in Las Vegas. The Frontier has a gaming license. Its people are licensed. But the ownership by Polizzi was not disclosed to Nevada authorities. And that's illegal under Nevada law, or at least Nevada regulations. And the trial court held that the business was involved in gambling. Polizzi's interest was a violation of Nevada law. Thus, it satisfies two elements of the Travel Act. Now, Polizzi's argument is that, wait a second, Travel Act covers traveling interstate commerce to conduct an illegal activity. VFI, Vegas Frontier, has a gaming license. It's not conducting gambling illegally. And even if the license is acquired fraudulently, there's no criminal violation of Nevada law. It's a regulatory violation. And really, the Travel Act is only designed to reach wholly unlawful businesses, and Vegas Frontier is not a wholly unlawful business. It's actually a licensed gaming operator in the state. Therefore, the Travel Act doesn't apply. And on top of that, if it does, if you think it does, it's unconstitutionally vague. Oops. Now, Nevada statute clearly prohibits Polizzi from owning an interest in the Vegas frontier. So with regard to his argument that VFI is a gaming license, court's not buying it. And it says that while VFI was licensed, Polizzi's interest was not, and thus the underlying violation of state gambling prohibition is present. You own an undisclosed interest in a licensed Las Vegas casino. That ownership is prohibited by Nevada law. Therefore, you're violating the law in Nevada, and you travel to Nevada to check on your investment. That's a Travel Act violation. And with regard to that argument that because VFI is licensed, gambling activity couldn't be illegal, the court says no, it can reach. Because, whoops, the violations at issue for Polizzi aren't violations of VFI, but of him, and those subject to this opinion. You know, it addresses the illegal activity of those in control of VFI. And by violating the license requirements of the statute, Polizzi falls within the catch-all of the criminal penalties for unlicensed involvement in gaming. Therefore, the predicate criminal state offense is met. Oops. And, you know, with regard to that argument that it's got to be a wholly unlawful business, that's not what the Travel Act says. It wasn't designed just to apply when a business activity is absolutely prohibited. So that limitation is not in the Travel Act. The court's not going to apply that limitation. As far as it being unconstitutionally vague, no. You know, you Polizzi knew you were violating Nevada statutes. You didn't make any argument that the travel wasn't used or that you weren't traveling interstate commerce. You knew what you were doing. The Travel Act convictions stand. And this is a really powerful use of the Travel Act for Nevada. Because again, remember, this is 1967, 1969. This was a time when Nevada's Modern Gaming Control Act was relatively new. And hidden interests in casinos were common in the 50s before the Modern Gaming Control Act. They were prohibited by the Modern Gaming Control Act, and the state was really trying to clean this up and make sure that everybody that was involved in gaming was suitable. But it was difficult to do. And now the state of Nevada has a really powerful tool with the Travel Act to help Nevada enforce its laws about hidden interests and ownership, and making sure that everybody involved in ownership has a license. And again, this is before we had the publicly traded company statutes as part of the NRS 463, the Modern Gaming Control Act. At this point in time, you had to be a closely held corporation, and everybody that owned a piece, well, you could be a sole proprietorship as well. Everybody that owned a piece or a partnership, but all owners had to be licensed. So a really powerful tool. And if you were caught in traveling interstate commerce to Nevada to check on your investment and you weren't supposed to have that investment, you just became a federal criminal. And federal penalties are severe. So this was a big, big deal for us. Now, there is another opinion in the materials. It's the Ruiz opinion. It's in there because it's a Supreme Court opinion, and it's the only one that touches on gambling.